The first time I reviewed the documents personally, when the copies were made for us to have a look at it by the Attorney General and to have a conference to discuss the details, I actually cringed. I couldn't believe it. The facts were like they were concocted, to be very honest with you. The facts were like they were concocted. Because this was not just stealing, but as to borrow a word from Dog, naked thievery. You know, in one of the charges, something, do you know what happened? The boss of Sh0cking decided to give a loan to a rural bank. And they did not even reach any agreement. Yet the money was transferred to the rural bank. When the money got to the account of the rural bank, the people then asked, okay, so what is the interest rate of the money you have sent to us? Imagine, something that you should have done earlier was not even done. Then the interest rate was then quoted by Sedina. When the interest rate was quoted, the rural bank management said, look, the interest rate you have quoted, if we pick this money, we cannot make any money out of it, so we want to return it to you. What do? Good corporate practice. You write to them and give your account, Sh0cking account. Then they pay the money directly into the account and produce receipt for accountability purposes. You know what she said? She directed them to cash the money and bring it to Accra. And then they cashed the money in a Ghana must go, carried it to Accra. They met at Bachona filling station, Total filling station, and the money was packed into her boot and she drove away. And that ended it. She's been convicted of that particular charge.
Yeah. So
then the second one.
Yes.
I'm giving you, I'm just itemizing them because I have the facts. I don't need to even read anything.
Yeah.
The second one, they were supposed to do some nationwide sensitization workshops for some category of persons with respect to matters like this. The money was about 2 million Ghana cedis. Less than 5% was used for the intended purpose. The rest was shared. As if it was ground nuts. Look, there was a fire disaster in one of the markets. Some money was allocated to help the victims. Just a little percentage of it was used. The rest, they shared it. There were some phones they had to buy. One on the market, 100 cedis. The prices they quoted, 400 each. Clearly, some vehicles were procured. In fact, those vehicles even delayed the trial because we had finished all the charges and then we bumped on a report which indicated that vehicles had been bought, some of them at thrice the market price. Some at thrice the market price. Some at twice the market price. We had to amend our charges to include all these. And remember that they were found guilty of over 70 charges. All of them.
78.
Yes. In fact, it is one of the most nauseating cases I have come across in legal prosecution. Because the act of impunity, naked thievery and robbery perpetuated by them was frightening. And you see, when the judgment was read, I posted something on my social media handle. I indicated that it was not a moment for anybody to celebrate. It was not a moment for anybody to be joyous, but for us all to have a sober reflection.
In fact, Ch0cking after Ch0cking has been saying, all those in office now, take a cue.
That's what I'm just coming to say. You see, you have to be very, very careful. Day of accountability will come. And when it comes, you will be in that dock alone. And the wheels of justice may grind slowly, but in the end, when the pronouncement is made and you are taken away to Nsawam, you would come to the realization that acts of impunity cannot go unpunished and go forever. If you look at the conduct of even the principal person, which even made Justice Sh0cking very angry. I mean, that the state didn't take enough steps or action to be able to have her in Ghana to face trial. Because clearly whatever she did it in order to evade conviction. That was why they had to try her in absentia in line with the constitutional principle and dictate. But I'm saying this again, that those in office now ought to take a clue from this. And this is the third time, and all those cases passed through my hand anyway, as Deputy Attorney General in charge of criminal prosecution. This is the third case of a very nauseating nature. The first one was NCA. At a point in time, some money was shared like groundnuts. And they secured conviction. Then this one. And the third one, you remember, venture capital. Do you remember venture capital? In that particular case, they had to take advantage of Section 35 of the Courts Act. And then they did a plea bargain. They were convicted, and then they went ahead to pay. If you look at a combination of these cases and the convictions that have been secured, and then at least the amounts of money involved and etc., a lot would have been saved to this nation. But as I have stated time and again, those in office now ought to take a clue from this. And I thank my brother Sh0cking for the statement he has made. They have to take a cue. Because it is very, very, very juicy.
Initially, the court,
to dip your hand in there and fetch.
Initially, the court, there were people who were very critical about the court, that it was not being sympathetic, she was not well, she needed bail to be able, she needed opportunity to travel, take care of herself. And this was like a media trial. And eventually the court had to succumb and say, well, go and take care of yourself and come. And she goes, she doesn't come.
She doesn't come.
The question Ghanaians are asking now is this judgment as empty as the paper?
Well, something.
The name trial, Sh0cking, we are Deputy Attorney General, right?
The torso.
Oh, but the torso.
A brana, a penka, the torso.
Okay.
Okay.
Okay. I mean, sir, Osha grounds of appeal now. The first one was the charge sheet was defective, and you would realize the Court of Appeal ABC or decision mainly on that first ground of appeal it was saying, I mean, a defective charge sheet and answer then.
So yes, Court of Appeal judgment you are right. They are more comfortable rely on defective charge sheet. But the DKP say I disagree with the Court of Appeal. They didn't do a good job. Judgment not even stand the test of any legal scrutiny. Now, the mention the Americans.
Okay.
In your lawyer media, lawyer media would see me the MPO for argument's sake. The charge is quite a defective one. And just what the panel Ujano by the appellate court. May come Section 31 of the Court Act. Check 31-2. Now, said the Parliament in Maxwell, Omutroyo said the Court of Appeal, as any appellate court, will be on the ground say charge sheet a defective. Provided say miscarriage of justice MIA and so evidence via any record Nipano before. So the Court of Appeal is faulted firstly by Section 31.
And it's your considered opinion, sir, when they establish a charge sheet very defective, no? What should have been the decision, sir? They order a trial de novo? And I'm
coming there.
Okay.
I'm coming there.
Okay, that's fine.
So the first time I say that's a defective, no? Next phase in it, she say, a dance here a warm crack no. A dance here is support to any other charge as you have it now. And I am pushing your catch them and say, what work as a charge a defective one. What you do is say you order trial de novo. Exactly. Because Ebasana is on technical ground.
Yes.
So, because we are talking about 90 million Ghana cedis. And I can want it. But I will say, cash sheet, defective. So that's the first point.
Okay.
Second point, now a dance here, court anymore, court we boon any fast one, and a dance here one could be changing so, like I said, judgment, Edimuana, like I said, amen. Edi kind 500,000 Ghana cedis I can't say must look for the command that institution or Ashanti region no. A dance here the court and say Emrasa microfinance company in sa cash the cano. Omu say interest was no moon to be chia. Don't me some more the checks. Ebra must look my temakulu. Now send it can't be a factory. Mamma said Debbie on a board chairman, no Cassa said, Debbie, me near cash. A dancing American to be a what dancing. Yes, I cash no bank, that institution is cano cash at the bar and kind. But you'll be sure, mamma, no kind. There's a filling station, Barcelona, filling station. There are dancing, Sahono Mushiano,
Okay.
and on this cano, a shenison. Then I'll choke that and a sackers cano. But the sackers cano, while found commerce lock accounts will be. It's a great dancing. Yeah, judgment and say I still say a dance here anyhow. So that's the first a dance here solid. Unless say could be a patch and say you can't dance there, my Jesus Christ. If you are him when we are quarter any a dance here. Solid a dance here. Number 2, a dance here a one craft as well say. Mami Tamaklu Mra Eja a shake cantamanto. Omampani Mahama Samre 2013-2014. Because on mining first time master for na says cano umfan koma get the mano and show me omujum. First can similar wrong at almost 1.4 million Ghana cedis. Audits na yeah the kids it shows say can the core man hono close to 700,000+ Ghana cedis. Almost 600,000 or 700,000 there cano anko man biaho. And we are dance here. Report no at that court fan or so. Number 3, Maslow, say, sensitization program from a mana, from Hono, about 80,000 of them throughout the 10 regions, 10 regions organizing. And on budget close to 1.8 million Ghana cedis. Mami Tamaklu, Eco region, and Sape, out of the 10. Yes, so called, yes, it's called spending a pay within 1,300, meaning I maybe 13,000. 1,003. So we almost 1.7+ million Ghana cedis, no, and also of fire. Another one. We are financially literacy for our clients maybe. In terms of 246,000 Ghana cedis. 1 year when you spend even 1 cedi out of the amount, 1 year program na nipani biya. That's kanu pasen fan come back. Do you dance we a war in Kratemu? And the last one, almost talk has been 350. Yeah, the dance by and say, can in a cost pano a $10 million. Now, so we have $14.5 million. Yeah, a dance and the sun in my inina a womb. Now, the same a more cranny say, I dance at the bay more good no, mamma no, you know, say, oh, my court, it mean and say, I deal with it, and you know, still it here. So, on what basis? The court of a PC say a dance here in this same with me. Again, I'm going to make also obedient that can so when I know correct, Mr. Scanner by the Koha, the winning Koha, then that case all 2 sides. Minister criminal prosecution, the state must prove his case beyond reasonable doubt. But on the side of the prosecution, I mean, I can tell you without any equivocation, the case is said the state prosecutors are only a Duma way no, only a Duma party tells me the man we. The public servants on we investigators on Yoko. The kind of Juma we are auditors, a Juma don't be a dance or court. The other court to Ghana, like court of because a dance anywhere. Like I say, a idea, maybe 2 months.
But lawyer, even before Sh0cking, the whether the charge sheet was defective and answer any defective, no, on even the evidence, no. And the probative value according to evidence, no. The Court of Appeal in Omu conclusion page 92, 93, and 94. Mintimin kind, and I'm only taking a cursory look. So I share conclusion almost say paragraph 120. It has long been the golden thread running through our criminal jurisprudence that the prosecution must prove the guilt of the accused, and that this burden never shifts unless the enabling statute or law has expressly and clearly said otherwise. The principle articulated by Viscount Sh0cking in Wilmington versus DPP, our law student BN, say, and Sh0cking sins is not a technical nicety of procedure. It is the constitutional expression of the presumption of innocence, and it is owed to every accused. 121, I'm going to say, the learned trial judge lost sight of this. Confronted with a charge sheet drawn mostly in negative terms, that the appellant had acted without authorization or without due process, she reasoned that because the prosecution had averred a negative, it fell to the appellant to prove the positive. That authorization, process, or justification in fact existed. With respect, that reasoning inverts the very principle it purports to apply. 122. The manner in which a prosecutor chooses to draft a particular offense cannot, of itself, relocate the burden of proving an ingredient of the crime. A negative averment, artfully or carelessly pleaded, is not an exception or proviso. It's not an exception, a proviso, or a statutory defense. It remains in substance an element the prosecution must establish, and the difficulty of proving a negative is the prosecution's difficulty to bear, not the accused to solve. I will go further to emphasize the principle that unless a statute plainly places the burden of proving a particular element of an offense upon the accused, she is under no obligation whatsoever to lead evidence in aid of a prosecution's case that has not yet reached the threshold the law demands of it. To require otherwise is to ask the accused to complete the prosecution's unfinished work and to convict her for declining the invitation as was done by the learned trial judge. The prosecution's evidence on a fair and unaided reading fell short of proof beyond reasonable doubt. The shortfall was not made good by any burden properly resting on the appellant, and the trial judge's misdirection on this fundamental point goes to the very root of a fair trial. For these reasons, therefore, I am satisfied that the conviction and sentencing on all the charges, including those manifestly defective charges, cannot stand. I would allow the appeal and set aside the appellant's conviction and sentencing on all count. In the way and Justice Emmanuel Ankama, I'm not sure this lead opinion, no? One, the evidence he believes said you couldn't prove the case beyond reasonable doubt because that it was for you to prove and not for the appellant, no, to rather prove positive. When you crafted the charge sheet, no, in the negative. Okay, hold counsel.
Before what kind, the judge misapprehended, misunderstood the import of the prosecution's case. With a great respect to the judge, his appreciation of the burden of proof, wrong. In criminal cases, the state or the prosecution is supposed to criminal cases. They'll say, there are some court, if you prove a case beyond reasonable doubt.
Yes.
Everybody knows this is not something the judge should lecture anyone.
Yes.
Now, who we are, then the accused person will have to just raise doubt to show, say, the okay, no prove beyond reasonable doubt, something that everybody knows. So, before what you know, to me, it does not answer the question. The key question is, charge sheet that the state prepare, you must prove, you must get evidence to back the charge sheet that was required. The advance ye bia e wo se state ninya state no the advance ye by ma minus krata na o sign say scan magic cash free mo nipo diska buy no ba ka say o ba be share no bacho na filling station and can manage scan accounts on prepare and issue say one first can go to company we say accounts no e the get up so chere before kai na meaning say scam manage ye no before kata so na no, that is not how the law works. With all due respect, the trial judge, a very good analysis of the judgment. I mean, you the judgment and the first one judgment now. To the extent say, or evaluate the evidence, Mamma, the question is a lawyer or consider it, including Mamma the statement of the police or consider it. So the judge, the court of appeal is a little now say, if the accused stating proven case beyond reasonable doubt, the accused person can say, I will not speak, and then the court will acquit her. No. The court can say, you have a case to answer, and you do not answer. The court can go ahead to convict you. And before the court will say, so case to answer, no, the court must be satisfied, say, there's evidence on record. So the greater respect to the Court of Appeal, they grossly erred. Even when we talk about a charge sheet, say defective. We had when already and
yes.
some of are defective. And so what? Section 31 is clear. Section 31 of the Courts Act is very clear. Section 406, subsection 1 of Act 30 is very clear. The Court of Appeal got it wrong. The trial judge got it right. But Court of Appeal has 3 judges against 1 judge. The Supreme Court will have to step in to see, because this particular judgment, so much as dance a woman no any dance meet the threshold, and the sort of court media dance amount. We are no magicians, but every single ingredient here can be no state in terms of the catching of the chances they will be in the negative or positive. Whether negative or positive, the state must prove its case. So it doesn't matter the language. You are supposed to lead evidence which you say the war cannot. We never said the same. I'm proving innocence. The Court of Appeal, they should also know that. You also know. Then no, the state never says to them, "Mami, you come and prove her innocence." That's why the trial judge evaluated too. I mean, if you look at the Court of Appeal at the abonnent page, go to a trial judge judgment, not the abonnent 4-page judgment, and then look at the analysis for making it against the Court of Appeal judgment. To me, plenty English. Ghana for a seeker over 90 million Ghana cedis and a Court of Appeal. It's technical grounds. Because then we can be Simon. Empo the charge sheet is defective. A court doing substantial justice and a court minded say also a protected state resources. I'm deciding you go back so that the matter can be tried again by the court.
Indeed, then no on or better discharge. Yes.
Because that's on 30. So if we Court Act and I look at the Court Act, how would you put and in the Act,
maybe Section 31 of the Court Act.
Yes.
Appeal in criminal matters allowed on substantial miscarriage of justice. I know ne subhead there, no. Was it 31-2, right?
Yeah.
31-2, good. 2, they say the court shall dismiss the appeal if it considers that no substantial miscarriage of justice has actually occurred, or that the point raised in the appeal consists of a technicality or procedural error or a defect in the charge or indictment, but that there is evidence to support the offense alleged in the statement of offense, in the charge or indictment or any other offense of which the accused could have been convicted upon that charge or indictment.
Okay, you the whole plane. So Court of Appeal telling us this section no and I mean yes, was section 406 of Act 30 so 4061 bit me here no so.
Okay.
So as a lawyer, speaking as a lawyer, I can say the Court of Appeal has done a great disservice to the people of Ghana in this particular matter. They seriously erred. Our judgment cannot stand the test of legal scrutiny. A combination of whatever the judges think should be the case, but looking at the evidence on record properly so-called, the trial judge, the judgment, and also Ghana for I will be speaking as a politician, as a party in that case. I rather urge people who need that kind of thing. So they should take the judgment of the trial judge. No more Court of Appeal. No more law. No more Court of Appeal for the support. I'm ready to support all manner.
What I'm telling you is, you are now able to draw a conclusion as a political party that there's travesty of justice. That's what you told us.
Yeah. So okay. So now let's
you have an opinion on rulings of courts.
No. Okay. So just set the ruling one way for now, because you and I are not judges.
You don't want to go back and look at the High Court ruling?
No, we can look at it.
It's on the basis for which an appeal was made.
Just relax.
The evidence hasn't changed.
Relax.
Nothing. No facts have changed, and that's the process of appeal.
Yeah. So we are not making any progress. If you just allow me, I'll make the point that we can make progress.
No, but if you can answer my question.
But that question is a disruptive question.
The reason why you don't want to answer
that question
that question
that because I am not a judge.
You're picking and choosing.
No, my subjective judgment on the ruling doesn't amount to much.
Do you disagree with this latest? Do you disagree with this latest ruling?
Where are we starting from?
Do you disagree
are jumping
with
from
that?
issue.
I'm asking you.
Ground the conversation. No, hold on. No. You can't leave it.
Okay, so I'm asking.
Ground the
Did
conversation.
you believe in the High Court ruling?
It is not about my belief.
Do you believe in the High Court, the Court of Appeal ruling now?
What does my belief add to the conversation?
Your party just released a statement indicating there's a travesty of justice.
No problem. So let's get to the conversation.
No,
the conversation
answer my question first, then you can speak to your statement.
You are not asking a question.
My question to you is, did you believe that justice was served, said Sh0cking, when the High Court decision was made?
But is that not what you're expecting in a judgment?
Is that what happened to you? Is that what you see the process to have been?
But what else should I...
So justice is not being served now at the Court of Appeal?
Where justice means what to you now? What is that? That she's freed is justice to you?
It's part of the justice process, isn't it? If you go to court, you have two outcomes.
Okay, so you see where you are standing. You are standing naked, okay? You are standing naked. Because really now, the Attorney General disagrees with you. And you are saying that her acquittal, is justice. That's what you're saying. But Attorney General disagrees.
I'm saying that based on the judgment of the court. Excuse, with all respect to the Attorney General, I don't care
reposition the conversation.
I don't care what the Attorney General thinks about it.
So let's
I'm sticking with the reality now. The reality is that someone has exhausted the judicial process. There's an outcome to it. I'm asking you if you believe in that now and what happened before.
Okay, so forget about what I think. Let's look at the issue, independent of the two of us. Okay. Right. The matter here is that an individual has been convicted. She ran away from justice on bail. She didn't show up. That is a dishonest conduct to begin with.
By whose standard?
Huh?
By whose standard?
But you have a bail, which is a testament that when you need me, I'll come.
Yes.
Okay? And then you bolt after that. It's a dishonest conduct. By everybody's standard. I gave you my word that I will show up when you need me, and I disappear. And I went to hide in America. And I won't come till I was extradited to this country. I knew I was sentenced. I won't come.
Yeah.
And then when I got extradited and came, because my government is in power, instead of taking me straight to jail, they let me go home and cool off. And she was cooling off at the house until public agitation.
You've seen her at home?
Constantly. But you don't let it go back there. You knew she was not in St0le when she came. She was in her house for about some 2 weeks. And then there was pressure. And Felix Ofosukwachi, the minister for government communication, was talking down to us, saying that, oh, why is people asking this? And I mean, we don't understand. The arrogance, we can understand it. Yeah. Okay, that period went by. And then she got to St0le. 2 days later, she's at the appeals court, acquitted and discharged. Don't you see a pattern?
And you're saying that's injustice?
There is, yes. No, whether you can call it what you want. But
you released a statement.
No. I'm not interested.
Your party didn't.
You want to pigeonhole the conversation. I want to give you evidence.
You can position of the political party on this.
Let your viewers reach a certain conclusion. I want to paint a picture for your viewers. This is an individual who bolted. Won't come to Ghana until her government came to office. She's come back to the country. Her government is protecting her. She won't go to jail immediately. She was sitting at home for 2 weeks. Then reluctantly, they sent her to St0le. 2 days after that, not literally, but a few days after that, she's brought back to appeals court, acquitted and discharged. Don't you see a pattern? If you don't see a pattern, let me go back and tell you. They come into government, all their people on trial, they issue a Sh0le prosequa, free all of them, okay? They are above the law. They are creating a certain class of people who are NDC people above the law.
Okay, can I concede
now everybody else should be equal to the law. Now you have juxtaposed that with what is happening with Wuntu, which is why the statement is calling for clearing all those people, because then we don't have a judicial.
As for that demand, Richard, I'll take you on that demand.
Yes.
But let's do this first. You've painted your picture, correct?
Yes, so a pattern has emerged ours is now an animal farm where some are more equal than others.
Okay.
And is that something you like? Is that what you want?
Obviously not. Today I'm conceding with you on that point.
Okay, so but because you have to, because you don't have a choice.
Can I add to your point?
Yes, go ahead.
Do you recognize that your Attorney General at the time, appointed by your presidential candidate, i.e. then President Akufo-Addo, did a poor job and failed this country by failing the basics?
I'm listening to you. What's that? We haven't said anything.
Richard, that's in the judgment. The reason for which the lady is being acquitted and discharged now.
What is that? What is in the judgment?
The charge sheet that for which Sedina was being prosecuted was defective.
Defective how? And her lawyers argued that. Her lawyers argued that in court.
That's the judgment. I wish I had the document.
No, but you don't have to have it. But I'm talking about listen.
Concluding to say that the reason for which no one for now is succeeding at still keeping her incarcerated is because the charge sheet was defective. That is injustice ab initio. That's the position of the court. I mean, I'm not quoting a political document for you. This is the judgment of the court.
Listen to me. My head is spinning at you telling me that.
Who was the prosecutor?
Listen. Let me ask you a few questions. You see, my head is spinning. You're telling me this, and it's as if you are indulging.
No, but I'm conceding your point and adding a bit more to it.
You see, here's the point.
Yes.
The monies that have been talked about, where is the money?
No, you're talking about money.
I'm coming. Hold on. Please. I'm not interested in what the conversation you're having.
The prosecution failed because you can't put something on nothing. That's basically the point.
I don't understand what you're saying. You see,
Richard, I'm quoting from the judge.
I don't see. I haven't read it, but you tell me.
It's a 94-page document.
I can't believe what you're quoting.
I wish I could.
Yes, but if you don't have it, why do you bring it for conversation? I haven't seen it.
Read that.
But I'm inviting you to reason about the matter.
You don't want to see
No, forget about the technicalities that they are going to use to free somebody. But I'm telling you, I'm inviting you to have a conversation about what it is we want to fight.
Yes.
We want to fight corruption. Okay?
Yes.
Somebody's dissipated state resources. We don't have the monies in question.
For now, you don't have the legal grounding to say she did that.
But the person has been convicted on that.
She's freed now.
Free on what grounds?
All other findings of any other inferior court would not hold now.
You know, when we are having these conversations, let's be mindful that what conversation we are having today has implication for our posterity.
That's what you keep doing at the NPP. The future is pregnant. You keep...
No, I didn't say future is pregnant. I'm telling you that... I'm saying that I didn't say it's pregnant. Pregnant means that it's going to happen. I'm just telling you that it has direct implication for our posterity because we are holding this country.
The future is pregnant.
I don't know what language that is. I don't speak that one. But I'm telling you that tomorrow depends on the decisions we take today. And we are talking about fighting corruption. And an individual has been found guilty of a certain act of corruption. And you are telling me that a charge sheet is defective, and it's defective on account of the fact that she didn't squander those monies. Is that the defect?
We're not going into that anymore because ab initio there's injustice. Procedure matters in delivering justice.
I don't know.
That's what the court is saying.
I don't know what your motivation is for lingering on this matter about.
You feel it's irrelevant? If you are being charged, now, Richard, because you were with the NPP as well administration, if the NDC picks you up now and takes you through an illegal procedure of conviction.
What is illegal about charge sheet being defective? If the charge sheet is defective, it means it's illegal.
If there's something substantial that is missing in the charges, obviously there's nothing to accuse.
No. Let's understand the language properly. Unless you have the statement here,
I have the ruling.
Well, you shouldn't have to introduce it if you don't have it.
I have read that. I have that on my phone.
Well, I don't have that.
Minutes ago.
I don't have that. But the point is that let's even come here. Let's have her come here.
Yes.
Forget about a charge sheet being defective. Whatever that is, you are talking about some technicalities to do with that. It is not evidence to suggest that the monies that were said to have been squandered was not squandered. That's not what you're saying. You're saying that some technical law courtroom matter is the reason why monies that were lost to the state should be let go because some defect has been seen on the paper.
Yes.
Would you do that if you run a business and they say, well, so some defect in English, in writing something, and so therefore the money lost to your company is gone for good and the person is to take it? I mean, I don't understand what logic.
It's a party that prides itself as believers in the rule of law. You believe equally, I'm sure.
Defective charge sheet is not necessarily...
it's tied to the justice system. Because, and let me illustrate.
I don't know. Let me
illustrate that to you. Under Article 19 of our
Constitution. Say that particular thing. Let's engage it. What exactly is the defect?
What
is the defect?
Well,
What is the defect?
I was just going to illustrate that to you.
I mean, no, I don't need illustration because now I see where you are coming from.
No, it's not.
But I'm just saying that.
I'm not making that up.
I'm not saying.
Point is,
so read it to me. Until
matters.
that,
you cannot under criminal jurisdiction. You cannot charge someone for a crime that does not exist. So if your charge is defective, but that is grounded in law, Richard.
Now it comes to, I haven't seen that, but you know what we're talking about here. You know what happened? No, hold on.
Buy me some time. I'll get that for you.
You know what you just said.
Yes.
What you just said.
Yes.
Listen.
Yes.
That is provided for in Article 1911.
Yes, precisely.
Okay. Right.
Your party believes in that.
But hold on.
Yes.
Right.
Yeah.
Just yesterday, when Wontumi was being tried.
Let me just.
Hello, I'm coming.
Go back to you because you are doubting me. This is the concluding part of the judgment, and it says, "quote." And if you doubt me, we can refer to the document later on.
Which document? The appeals court's ruling.
Yes, ruling.
Okay, go ahead.
Just it came some few minutes.
No problem. So what is it?
Yeah. So I just wanted to read that to you. Oh my goodness! I'm just okay.
You don't have anything to read.
No, listen. Quote. A sentence is not an autonomous judicial order. It is a penal consequence of a valid conviction. Where the conviction is set aside, the sentence is deprived of its legal bedrock. That is the analytical framework within.
Oh my goodness! When people this here, and I want to say this. Let me say this, as a citizen who is interested. I want to tell you that, you see, my outlook in all that I do in this political space, I serve my party, but I believe in the cause of my party to serve the interest of this country. So my engagement is about Ghana, essentially. And so this one grant me the opportunity to tell you, and you believe me, that I am not talking as an MPP person. What you
now you don't want to belong to your party?
Listen to the premise I've created for you.
You are speaking as a Ghanaian, an objective Ghanaian.
You understand?
Yes.
What you just read for me there is the problem. The court is allowing itself to become an enabler of corruption.
Also,
what you are talking to me there is a court bringing some technical matter to tell us. But the point is that I'm asking you a fundamental question. The fundamental question is that where are our monies?
Which money?
The monies that she was said
and
to
who's
have
answering for that, by the way?
She ought to be. And I'm telling you that right now, as we're saying, that effort that you just read is part of the grand effort to free her.
Let's do this.
And then,
if I ask you,
the Attorney General disagrees with you anyway, right? Even though I see,
and I'm telling you, I don't have to side
the Attorney General, the Attorney General,
Minister for Justice.
Hold on. The Attorney General, our position is that this thing should not have a reason to begin with.
Yes.
But now it has a reason.
Yes.
The Attorney General's intervention with the appeal or opposition to the ruling is, for me, I see as a rules part of the grand effort, but disagrees with the opposition.
With me,
necessarily.
It's fine.
So I'm saying that let's give it occasion to go through.
And
but the point we are saying, and why you are getting into all these weeds about what they have said,
you feel it doesn't matter?
I'm saying that when somebody has committed a crime, that the person has been sentenced, and knowing the pattern that has been created in this government, you can tell that where they cannot find Sh0le prosecutor to clear the person off, they would go and find some clauses like this to free the person. That is part of the grand design. So why you are falling for it, I don't understand. Because that's your resource that's been dissipated. Okay, all the people who ought to have benefited from that money have lost the occasion. So we are talking about deterring people from dissipating state resources, and you are busy trying to quote something you are looking almost with a goggle to find and read to me.
But it's in the concluding part of the document.
My goodness. Let's get serious for once.
This is a 94-page document. You should credit me.
It doesn't matter the number.
Level of diligence in trying to fish that out for you.
Well, I should credit you with a certain understanding that you are not focusing on the substance. On the real matter.
You
are focusing on the peripheral matters because you went looking with the microscope to find that one.
It's very important.
But that's not the substance of the matter. The substance of the matter is that we are fighting corruption. And this is freeing people from corruption.
That's exactly what your Attorney General and our Attorney General at the time, Godfrey Dami, did not do, paying attention.
No, you can't bring that here to have a conversation. She was properly convicted. Okay?
Yes.
And I understand that this appeal process that has come to fruition was filed during our time. But the question you want to ask, if indeed it was filed during our time, why was no effort made to move it in the court at the time?
Whatever the case,
because now, listen, because now, you see, you look at the pattern I'm talking about. Because now, her government has come, NDC had come, and they are doing all the shenanigans to free her.
They are well within the prescribed time.
I find it difficult that you don't want to see
notice of appeal. They've done that.
Which notice of appeal?
They filed that way before now.
Yes. So the question is that.
Yes.
The question is that. Why did they not act on it?
That's not my problem. I'm not lawyer for said matter.
But whatever you are reading there, you are advocating for her. But I'm telling you that.
Is it fair now to ask? Can I proceed?
Listen. Yeah, so you say you are not lawyers for her, and I'm telling you the reason they didn't do that because they knew they didn't have any case to appeal. But now their government had come, so they went to look for some clause in 94-page document that you alone have seen where it is to bring on your upfront program to come and advocate. When there is a whole business of somebody dissipating state resource, you are looking for me for a line to say that on that basis she goes free. How do you fight corruption if that's what you are doing? How do you fight corruption?
No, to be fair,
how do you fight corruption when if you are looking for a line in a 94-page document to free somebody?
To be fair,
are you serious about it?
Richard, no, that's not what I did.
I am shocked.
It's a whole gamut of issues.
I don't want to hear you for the rest of time for you to complain about corruption. If this is what you are going to be doing, using microscope to find one line in a 94-page document to say that somebody should go free.
I just wanted to.
I don't want to hear you say it.
The summary of the point. That's in the concluding part of the.
Please stop it.
Because the court effectively distinguishes,
let's get serious about this matter. We cannot be playing with these things.
If you're trivializing procedure, let me ask you this question: where is our money, and where is Ken Ofori-Atta keeping our monies?
Look at the movement from a matter before us to Ken Ofori-Atta.
So you believe that Ken Ofori-Atta is not being charged, right?
No, listen. Ken Ofori-Atta.
Procedure matters. So no one can go and ask him now where our money is, because as of now, it's not being charged. Correct?
What is your motivation?
No, I'm asking you the same principle.
Are we having a conversation for the public good, or we're having a conversation for blessed good, or are you in
I don't work for the court. No, I don't.
But are you a spokesperson for Madam Sedina? Because what you are doing is to dig out some what's called a contrived line in a 94.
Contrived,
yes.
You're impugning on my integrity. That's
I'm not impugning. I'm just saying.
I mean, it's not fair, Richard, when you do that.
No, I'm not impugning your integrity. I'm saying you found it, and I'm saying that what you found is part of a grand effort to free her.
Where's Ken Ofori-Atta keeping our monies? Is it fair to ask you that question?
I am not a court. I don't have the power.
So yes, the court has decided on someone.
No, I'm saying that
she's free. She never even has any charges to answer to in the first place because it was defective.
And I am telling you, I have told you a pattern of this government.
Your same principle,
Richard. My principle is absolute, and I believe in.
So can we go then and ask Ken Ofori-Atta where our monies are?
I mean, I'm not holding Ken Ofori-Atta hostage in my house.
Yes. So why is he in the US then? Same thing, same place.
Well, you should ask Sedina why she was in the US. Ask her.
So same principle.
Well, how did she come back?
So if you have a
problem, how did she come back? Listen, how did Sedina come back?
She was extradited.
Yes.
Yes.
So who did it? The state.
Is it fair to conclude that
I'm saying that who did it?
Away?
Follow the question. I don't know.
You said Sedina had run away. That was your conclusion.
Yeah, of course. She left.
Same thing Ken Ofori-Atta told us he wasn't feeling well. Today he's a permanent resident.
I don't know how you
know the US too well.
No, but I'm saying that. You
didn't play the US.
If you want to have a constructive conversation, we'll have it. But the point is that you are bringing in Ken. We can talk about Ken. But I'm saying that the logical.
Just an example.
No. But that example was disruptive in the sense that you don't want to focus on the conversation.
The principle. I'm just testing.
Forget about the principle. The issue before us is this: that there's an effort to free Madam Sedina Tamaklo. We now understand that she belongs to the category of animals in this farm who are more special than the others, more equal than others. So fine. I've shown you evidence, a pattern. So this whole thing that you are seeing from a certain paragraph, whatever, of 94 document, that one is part of the design to free her. Because you can nitpick on those things, but the substance of the matter is that our resources that she was supposed to be managing were dissipated.
By who?
You're asking by me? Was I the CEO?
The court's directive is that she has absolutely nothing to answer for.
If you believe that, let it be the case for our country, because but the point is that I am shocked that you want to advance that conversation.
It's a court ruling.
It's not a court ruling. Yeah. Well, court rules and they can be overruled. Is that not the case?
They have not been overruled as of.
But the Attorney General has filed a position to appeal.
So you believe in that process?
Which process?
The Attorney General's process, challenging that.
Challenging that, yeah. I mean,
you believe
in essence, yeah. That's what this whole thing, I've told you earlier.
Then that was not designed at all to free her.
No, you're not paying attention, because you just want a certain outcome of this conversation. The point I'm telling you is that this whole thing, appeal, shouldn't have a reason. Because if they filed the process, as you said, and I know, I heard that they filed it whilst we were in government, the question is that why did she not move on that at the time? Because she knew she doesn't have a case. But now her government has come. So she knows that somehow, she is now more equal than the rest of us. So there will be some line in a 94-page document that frees her. And you will find it and bring it on your program and make that a subject of conversation, rather than the enabling of corruption, which has become the order of the day since this government came to office. We have Sh0cking.
Yeah.
The buildings are still there. Yeah. Shells. Yeah. But $200 million have been dissipated. And this government has issued a Sh0le prosequi to discontinue the matter. As a pattern. And all the people that have been freed and cleared. And comes her case, they arrange for her to come. She comes in, she won't go to jail, sits in the house. When people agitated, they sent her there. Only God knows which part of St0le she was staying. They were staying in some of the officers' bungalows or whatever. And then finally they bring her to court looking good, and then say she's acquitted and discharged.
She's looking good?
You understand? So you see a plan that is a government playing with our minds. And I'm telling you that these are dangerous stuff that you're doing. It's dangerous. Yes. It's dangerous. And you were inviting me to talk about Article 1911. When you introduced the matter, you were here when we were having the conversation about it regarding Untumi.
Richard,
but the judge, listen, the judge refused the referral, to the Supreme Court for interpretation to determine whether what they were going to convict Untumi for was a crime to begin with, because it's not defined. And you have not advocated that, but today you are advocating that on behalf of Madam Sedina. So what is your motivation? You too, are you part of the animals that are more equal than others? What exactly is your motivation? I envisage that you and I will be here trying to fight for the public good. But somehow you are nitpicking. You are saying that a line somewhere in the bottom of some 94-page document calculated Richard, for a certain effect.
You just told me you were speaking as a Ghanaian.
Yes.
You are enjoined under the 1992 Constitution to uphold the principles, democratic principles. Yeah. And that should include fairness and justice. In fact, that's the baseline of our statecraft, right? Freedom and justice. Justice.
I'm not advocating for anybody's right to be abridged at all. Yeah. But I'm telling you.
So if a court order comes, I have no option as a journalist but to go.
What do you think would have happened?
Is that not prejudice?
No, listen, no.
That's prejudice.
It's a pattern. You are not following. There's a pattern.
You're creating that pattern.
Did I write a Sh0le prosequi that free the NDC people who are supposed to be tried? Did I write it? Did I write it?
You didn't write that.
I didn't write it. So the pattern is being created by this government.
But this is not. This is not a Sh0le prosequi. Just to.
But of course, because she's been convicted, so they can't issue a Sh0le prosequi. The process they can use now is what they have used.
The records. This is not a Sh0le prosequi.
But I didn't say it was a Sh0le prosequi. No. Do you think that even this, if all the, I don't intend to pick on Honorable Collins Dauda anyway, but the point is that, do you think that if he was convicted before they came and they wanted to free him, don't you think they'll find this other, fancy?
You're being hypothetical.
Oh, I'm just telling you, because he's been freed on Sh0le prosequi. The case is not being continued. The resource that he was supposed to generate per that 200 million is not there for anybody to benefit from. But yes, he's walking free. The money is gone, but he's walking free. What did the government do? Write a Sh0le prosequi, clear him, And then said in our Tabaclo, we can't write Sh0le prosequi, So what we do? We don't take her to St0le. Then people say we don't like it, take her to St0le. Then she comes back and go to appeals court. Yes. One time cleared and acquitted.
Yes.
Why? Why? Because they don't want
the incompetence of the prosecution.
Well, if that's what you choose to say,
this is the document from the court. I'm not, and you see all of these things. I'm not using my own words. If I have to be using my words, that's what's implied.
Well, because they have said it for you, you are using what they have said for you. That's okay.
But I'm
just saying. But the document, who says that is gospel? We are saying that the Attorney General will appeal it.
Yes. I
don't believe in the Attorney General's effort to be honest, but indeed, if it is, we'll follow the process and see.
Now you believe.
But I'm not telling. I'm sorry.
Now you believe in the Attorney General.
No, but it's a recourse, okay, for us to be able to get justice.
Yeah.
My fundamental test of this thing is that has the person taken our money? Where is the money? They took the money. The money is dissipated. And now you are telling me that there is a certain defect on a certain paper where somebody didn't underline something, somebody put a full stop, and so our money then suddenly is back in our pocket because somebody put a full stop on something, and they put that at the bottom of some 94-page document, and you are digging it out to say that is...
This carries the weight of the state.
You can call it what you want,
this
but I say you can call it what...
The second
it is for me a travesty. Okay, and a reinforcement of the pattern that has been created, unfortunately, under His Excellency John Dramani Mahamad's administration,
Richard, let me
to make NDC people more equal under the law than everybody else.
Let me be a bit more controversial. And so what? We allow Chairman Wontumi to be freed? Is that what you're saying?
I don't know where you say that. Wontumi, what is he convicted for? I believe fundamentally that Wontumi had not done anything for which he is convicted for.
He permitted illegal mining.
Huh?
He permitted illegal.
Okay, so what's happened to the person who actually did the mining?
But that's not my concern. You asked me about...
See the dishonesty.
No, but you asked me about...
You are asking me a question, I'm asking you a question, you don't want to answer yours.
You asked me about Wontumi.
We are asking...
You asked me about Chairman Wontumi specifically, and I'm telling you what he did.
And you say he facilitated...
illegal mining.
And then who did the illegal mining?
Who did the illegal mining? There's no court convicting any individual as of
But I'm saying that somebody did the illegal mining, which you are saying he facilitated.
Well, I don't know. I don't want to be liable to...
Don't be. But what are you talking about? Did you follow? As for that one...
Do you know anyone who engaged in illegal mining?
So as for this one, you didn't read the 94-page to see where the answer is.
But you know, I'm not being unfair.
You are being very unfair. I don't understand why you are doing that.
You know that's not the case. I'm saying to you that I know...
Hold on. You told me now, you just told me that Wontumi was jailed because he facilitated or allowed somebody to do illegal...
Convicted by a court, yes.
For...
Permitting illegal mining.
Permitting illegal mining. And I said, okay, I hear that.
Yeah.
Okay, that's what is on the charge.
Yes, you're asking me who committed...
Yes, so the person...
Who,
you don't have to know the person.
Okay, right.
But the person who committed the illegal mining is for which reason he is being accused for facilitating. Yes. Where is the person?
Do you know the person?
You see the dishonesty?
No.
It doesn't look good on you.
If you know the person.
It doesn't look good on you.
If you know the
person who became the friend of Attorney General Dr. Dominic Ayine.
Oh, they're friends now?
Yes, they're friends.
Because
listen,
the judgment of the court
don't distract me. Don't distract me. Hold on. Don't distract me. He became friends with Dr. Dominic Ayine.
Oh, the one who
and my good brother, Justice Sh0cking.
Okay.
They converted him to become their friends.
Oh, they're friends.
So collude with him to jail Wontumi for facilitating.
You're making serious claims.
Yes, of course, that's what happened. They made him a prosecution witness when he was the one who did the mining.
It's a crime now to make people witnesses in cases.
But you see, you make somebody a prosecution witness who observed and or was a witness that has not committed principally the case, the crime that you want to prosecute. But here we are making somebody. Okay, a prosecution witness who actually is the one who committed the crime you are trying to prosecute. And you let that person go. Somebody kills somebody. The person who killed the person become your witness, okay, to prosecute and jail the person who gave him the key to go to the house. Is this sitting well with your logic? That man is walking about. So what is our business here? Are we trying to prosecute people who allow people to go to concessions to go and do reclamation, and they took it upon themselves to go and mine instead of mind the business of reclamation? They took the extra step which they were not authorized. This is Wontumi's defense, that I asked him to do reclamation. I didn't ask him to mine. The man went there and took liberty. He took the liberty to mine in addition to the primary task. And now you being Dr. Dominic Ayine,
asking a small scale miner to do reclamation.
You being Dr. Dominic Ayine, You went to call that man who actually did the illegal mining, which all of us Ghanaians want to stop.
Yeah.
You let that man walk free, and the man will let him go on the concession. I don't understand in which world this makes sense.
I'm asking you a question. So
you blessed
a small scale miner to do reclamation. Is that what you're telling us?
Blessed.
Yes.
You are a fine guy.
Richard.
But you ought to be consistent.
I'm just
in fact, how many children do you have?
I don't have children.
Okay,
sorry.
You have children, and they are in your loins, listening to you right now and saying that what the hell is our father talking about?
What's this guy saying? Yeah.
What's that?
I will be old by then, so probably I'll have more reflections about.
Now, take your time. Purge yourself of these matters before you begin to break them, because you confuse them.
Oh goodness.
This thing with Untumi, it doesn't smell good. It is a travesty. It is wrong. Because why? What we want, what President Mahama promised, is to fight Galamsey.
Okay.
He didn't say that I will come and fight people who did not allow ministers to sign documents. The concession, how Untumi got it, is not what is at issue. What is at issue is that he allowed somebody to go and do reclamation on his land. And you want to nitpick on the fact that the person is a small-scale miner. But I give you a principal instruction that go there and do reclamation. If you can't do it, you can tell me. Okay? But if you agree to go and do reclamation for me and you are stealing yourself to mine, you have committed an act. Now, right, if you had convicted the two of them and say for you, for going there and mining when you were supposed to go and do reclamation, you are going to be sentenced as well. And say, Untumi, you caused... Listen to me. Untumi, you caused this thing because you allowed him to go there in the first place. You too will be sentenced, but not for Galamsey, but for facilitating the man to go to the concession. Then you can have some semblance of reasonableness to have a conversation. But the man who did the Galamsey is walking about, became Dr. Dominic Ayine's friend.
I see.
To prosecute the man who just didn't get signature. How is that reasonable to you?
Richard, will you allow, and I'm just assuming without admitting...
Answer that question. How is that reasonable to you?
Okay, it's not reasonable.
Do you see reasonable?
It's not reasonable, but can I ask you a question? Would you allow a first-year medical student to carry out surgery on you as opposed to a surgeon?
I don't know where you're going with that.
Okay, but you know the obvious answer.
I don't know, because you are talking about small-scale mining.
Yeah, I'm talking about skills now. In the context of it.
Okay, fine. Okay, so now proceed with your question. I won't allow.
You have to give me your answer.
No, I won't allow.
Between a first-year medical student and a surgeon, who would you prefer?
I want somebody who is seasoned.
Seasoned?
Yes.
Would you allow a small-scale miner or someone who does mine support services, regulated under law in this country, to carry out reclamation on your concession? Which of them, as a responsible citizen, would you...
Apples and oranges.
Okay.
Closing pits with equipment.
It's not just closing pits.
I have seen
this
this whole thing, what you need... I'm coming. Follow me. No, please. This is not rocket science. We have seen it.
Reclamation is not rocket science.
No.
You just fetch soil and pour into...
I'm saying that.
Into the holes
you think that a guy... Was it him who sat in the heavy equipment and closed the thing? No. There are experts, operators...
He couldn't even afford the...
I'm saying, that's fine. So
he couldn't even afford it. Someone wants to be bought that for helping him buy that.
No, I don't know about that. But I'm just saying...
It's in the ruling. It's in the same judgment.
But that is not material. That is not
the 94-page
that won't lead us to any conclusion whether he bought it or not. I'm telling you that... The fact that you say he procured the services of somebody who is not an expert in reclamation, granted, is that offense equal to 20 years in jail?
The law gives a threshold, isn't it?
But no, what crime is that? That I am supposed to get you. Hold on. I'm supposed to get you, blessed, as opposed to somebody else to host a show.
Yes.
Okay? Yes. And out of my naivety, I get somebody else instead of you, the Don, right? And that person comes to host the show, and the punishment comes. Is it the same as Is it the same as committing murder? Is it the same as committing Galamsey offense? No. You can't jail somebody because he has the indiscretion, exercise the discretion to procure the services of somebody else. So that indiscretion is tantamount to jailing him for 20 years. Don't you now follow the absurdity of what is happening to Untumi? Can't you see it now? So if all his crime is that he procured the services of somebody who is a small scale miner, okay, because he was naive about who he should get, then you jail him for 20 years. Where is it prescribed that when somebody don't fail to procure the services of an expert, then you jail them for 20 years? Where is that? Where is that?
The Mining Act.
Then the man who actually commits the mining is working free because he become your friend as a state.
The state didn't accuse Chairman Wontumi of conspiracy. Conspiracy takes two to tango. In this case, he was prosecuted for facilitating. There's a difference in it.
And I keep asking you the question.
Yes.
Permitted who?
I think we should ask
permitted who?
Permitted who? That's inconsequential. Because if you commit a crime...
I'm saying that your kids are listening to you in your loins and they're upset.
And they're so happy about how I'm working out key issues in the law.
So listen.
Yes.
So why
contravention? That's what you need to be liable.
Hold on.
When you
why did you put Wontumi in jail? Because he facilitated.
If someone trespasses your land, I'm sure you would want to get that person arrested, isn't it?
Where trespass in this case means what?
Yes. So the other
where's the trespass?
Liability.
Where's the trespass?
No, my point is
the man did not trespass. Wontumi says go and do reclamation.
Yes, okay. He can.
And the man listen.
On that
so now you see where we're saying that case, in my view, was inconclusive because the state had compromised the man, Mr. Sh0cking, to become its friend.
Yes.
In a certain collusion to jail Wontumi by all means. He has a collusion. Right. Because what it is a collusion. You see it clearly. Right. Because you are jailing somebody who, what he did merely was to show somebody a pathway to go here. And the person went there and killed somebody. Okay? And in our society, we frown on murder. Okay? So the two people, one showed the way and another went to commit the murder. Now you said that the person who showed the way, perhaps he didn't know what the person was going to do because he clearly told him go and do reclamation. And he went there, instead of doing reclamation, went to mine. And in our society, we frown on mining. So if you want to punish these two people, or if you want to punish anybody at all, in your wisdom, who should you punish?
Okay, Richard, we need to go.
Answer that question. Seconds. Who should you punish?
If you give someone your room to stay in, you'd go and check the room after the person is gone, isn't it? Anyway,
we have a long way to go. If this is,
we do have. If you have a message for the president, just speak to the president.
This kind of journalism would kill our democracy.
It won't.
It is.
You should trust me.
Because when you are reading 94 some page in a 94 document, and that to make that a substance.
10 seconds, talk to the president and leave me alone for now.
His Excellency John Dramani Mahama, the President of the Republic of Ghana, I love you. I respect you. You have accomplished much in your career. This that is happening under you now, you must not allow to continue. You are creating a certain pattern that in the future, others will mimic. They will mimic and say that the last time it was okay for some people to be above the law. And if we allow that to fester, this our country, this our democracy will not survive because others will do it and confidence in our judicial system would weaken, would wane, and we won't have a country. That is not the country we want to build. Please, the buck stops with you. Call your government and the people responsible for the justice system to order. Let everybody be equal before the law.
Equality before the law, that's what the New Patriotic Party is asking for. Richard Ahiangwa, Director of Communications for the NPP.